Hi, everybody. We're going to spend some time together talking about veterans benefits along what we're going to refer to as the continuum of care. So hopefully this will help all of you who are veterans or surviving spouses of veterans understand that there are incredible resources available to help pay for long-term care. Next slide. Just to introduce the law firm, we have bricks and mortar buildings, locations in Media, Pennsylvania and Westchester, Pennsylvania, but we actually serve clients really through the Delaware Valley. And our practice is very specialized in terms of life care planning, also elder care planning, Medicaid planning, estate planning, special needs planning. But the piece that we're talking about today is really the veterans benefits and how does that relate to all of the long-term care work that we do. The problem that we are facing, all of us are facing, is that long-term care is really expensive. So before we look at how much things cost, let's just understand what the continuum of care means. Everybody has an aging plan. And if you ask most of them, they'll say, well, I plan on being completely independent until the day before I spend my last dollar bill, and then I will peacefully die in my sleep. And that is all that they're going to think about. The idea, though, is that what if something happens? And the what might happen relates to the possibility of illness or a sudden medical event that takes somebody who is independent and moves them up the continuum of care. And so you may be independent at home and then all of a sudden find yourself perhaps needing some home health care, or perhaps the structure that you need is adult daycare, where you go off site and actually get support either for a half day or full day help. Or perhaps you might drive by a personal care residence. An example would be Sunrise, and think perhaps I need to transition or have a spouse or loved one transition to personal care. Assisted living is something short of a nursing home, but set up to take care of people that could be in a nursing home, but is not actually at the highest level. And Pennsylvania has fewer than 65 assisted living residences. So when you're using the language of continuum of care, in Pennsylvania, we're going to refer to personal care. And then we have nursing home, skilled nursing facility. And what people are amazed to find out when they have an unexpected crisis is that the monthly cost for nursing home care is $14,000 a month or more. Or what they're surprised to find is that if you do need to get some home health care, that's $35 an hour. And if you multiply that by 24/7, you can quickly see that the per month cost is going to be somewhere between $20,000 to $30,000 a month. And so the question that we all want to understand is, how is it that you pay for these very expensive but very important critical support services to keep you in the least restrictive setting? I've never had a client come in and say, I really hope to be in a nursing home on Medicaid. Most people are going to say, I hope to stay in my home. What I think you're going to find is the Veterans Aid and Attendance Program that we're going to talk about today is an important piece of reaching the goal of maybe being able to stay home. And what the statistics are, research shows that 100% of us will pass away. There's no other way off the planet. Yet how many of us will say, well, if I die? What's more remarkable, though, is that many people don't think they will ever need long-term care. And there are statistics. One of them shows up to 70% of us will need long-term care, whether it's short-term or long-term care. And there's lots of statistics that will explore how long the average stay and things like that. But you can see that even if you have a short-term stay at a nursing home, it wouldn't take long for you to accumulate a significant private pay bill. So the problem is how do you find good quality care? How do you keep yourself lower on the continuum of care? And then how do you pay for it? So let's work on that next. There are very few places that you'll be able to look for support to pay for this long-term care. And again, where are the surprises? Many people assume that their Medicare coverage, the health insurance that they got when they turned 65, or if they became disabled, they're assuming that the Medicare has a benefit that will pay for long-term care, especially in this. And the answer is no. Actually, Medicare insurance coverage is set up to have short-term acute level coverage. If somebody's in a nursing home, the maximum number of days that they may get would be 100 days for that spell of illness. And depending on the type of Medicare insurance you have, there may be cost sharing under Medicare Advantage, or if you're on Medicare and do not have a supplemental plan, there may be copays and deductibles. But even if you have full original Medicare with a great supplemental plan, beyond the 100 days, what families will find is that they might have private pay bills. Where's the other surprise in Medicare? Many families are surprised that at day 20, the Medicare coverage may actually be terminated. And their question is, well, where's my 100 days? That's a topic for another day, but I will mention that you should refer to the Center for Medicare Advocacy. They have toolkits that relate to trying to ensure you get your full 100 days. One of them is referred to as the JIMO Settlement Toolkit. Now, Medicaid. Medicaid, what is the surprise for Medicaid is that, yes, it is a program that's meant for the poorest of the poor, the ones that automatically qualify based on having assets of under a few $1,000s. However, another topic for another day is, how does Medicaid really support the middle class, and to understand how the Medicaid rules apply, especially to married couples, where if no one explained to you that Medicaid actually was meant to help that healthier spouse, there would be many things that you'd be missing. So the message for Medicaid is, don't assume that it's not a program for you, and that if you do have a spouse or a parent in a nursing home setting, you should absolutely have a review of how the Medicaid rules apply to your loved one. Long-term care insurance. If you have long-term care insurance, you're very lucky. If you do, you also get letters every year, and there's the surprise there. Long-term care insurance companies, the number of companies that offer them, those producers, have shrunken considerably, and there may be 3 or 4 companies now that will sell a brand new policy. And for the existing policies, what the families are finding is you may be getting annual letters saying, you know what, if you want to keep this, we either have to raise the premium or decrease the coverage. And there may be all kinds of variations. When you get that surprise, that letter, please know that you can call the insurance company and actually have them run illustrations for different kinds of coverage. And we also encourage our clients to call us, because we definitely have ideas on how their long-term care insurance can dovetail with some of the Medicare and Medicaid rules, so that we don't pay for over coverage, but don't give up things that we could absolutely need if we needed to have planning. And then the next pocketbook is savings. Sometimes the challenge, the surprise, is that the family who has saved for a rainy day, only to have an emergency happen, is still reluctant to pay for some of the care that's on that continuum of care. And so my message to you would be, please don't worry if you have to spend some of your money on a rainy day, because if you do, and get good, careful advice as to how to get the most value for whatever you're spending, you may actually prevent yourself from going to a higher level of care. When it's raining, be prepared to spend carefully some of your money. And then adult children. Adult children, in many cases that I've seen, where the adult children are supporting some of the parents for fundamental expenses, whether it's paying real estate taxes, whether it's paying food or other types of things. They may or may not get reimbursed, but the adult children are often paying for in some cases, the actual home health care, or sharing the cost for the parent in a personal care setting. Please know that those adult children, there are strategies that we build into the parents' planning to make sure that we treat the family tree equally, and if there is a way to make sure that they are reimbursed or paid under certain programs, that we bring that to those children's attention. Unpaid caregiving of family and friends, there's a phenomenal, incredible statistic about the amount, the value of what is being done by our families and our unpaid caregivers, to the extent that it's more than whatever Medicaid has been paying. So again, unrecognized contributions by family members who are doing unpaid caregiving. Just so you know, the surprise there is that there are ways for us to build in compensation for those family members. And then we get to the veterans pension known as aid and attendance. So part of the elder law work that we do is to figure out where the person, our client, is on that continuum of care, and then figure out how do these sources of payments work to help them keep in the least restrictive setting. So in our law firm, we have what are called elder care coordinators. One is a former nursing home administrator, one is a social worker. And the idea is that it's not just understanding public benefits or understanding Medicare and Medicaid or any of these other sources of payments and how to use them, but to also understand the very human goal of wanting to make sure that we have good care coordination and good advocacy and education. So our firm is a member of the Life Care Planning Law Firm Association. And so our work on the continuum of care, we do know all about these sources, but we also know how to make sure we get good care. And then just to point out that transitions are really hard. Getting the right level of care with the right provider and the right funding source is really the idea of life care planning. Next slide. So when we think about the program of the Veterans Administration Aid and Attendance Program, that's one sliver of what the VA has available generally for all veterans. But in terms of what helps with long-term care expenses, supporting vets who are on this continuum of care, the VA actually offers a really broad range of programs and benefits. There are some vets who are already in the healthcare system. If you're in the VA healthcare system, you may already be supported with some care needs with a program called extended care. So the VA has, along the continuum of care, within the healthcare system, a way to directly access that support. VA also has education programs, life insurance, bury and memorial programs, and many, many other programs. But the programs we're focusing on today is really aid and attendance. Aid and attendance is often confused with a different program, which is the VA compensation program. If you're a vet that has a rated injury, you may be compensated with a monthly payment based on your rating. So this program, the compensation system, is really more akin to the Social Security disability, that people buy in with this insurance coverage, and if they become disabled, they ask the Social Security Administration to make a determination they're disabled. Based on your prior earnings, you will get a monthly payment. For a vet who has an injury, the idea is that that rated injury may entitle you to actually a monthly payment. So the scope of our presentation today is not actually going to include a lot of the nuanced information about compensation, but again, there's lots of information about that, and there is a lot of great work that's coming out of the Widener Law School VA Clinic as another resource, so that if you have questions about how perhaps to increase your rating to perhaps even 100%, it's a great resource to get started. So if we're focusing on the aid and attendance, this is similar to the program, the supplemental security income from, again, the Social Security Administration. This is based on a concept of restricted assets and income that is below a certain amount. So with you, even though it's called pension, VA pension, it really has nothing to do with the length of time that a vet may have served in the armed forces. It really is a matter of do we have an active wartime vet that meets other criteria? Next slide. Once you trigger aid and attendance, it puts you into the VA healthcare system. And then what is unlocked is the free outpatient care eligible for the burial benefits, prescription benefits, hospital and pharmacy, and then VA facilities. Aside from the compensation and the pension income payments, there are these other valuable benefits. And the aid and attendance, once you become eligible, unlocks all of those resources. Next slide. So if you are applying for VA aid and attendance, what is the hoped for result? Well, $2,358 a month for a single veteran, $2,771 for a married veteran. Now, there are some clients who may have substantial wealth and don't consider the idea of an additional check of $2,700 a month as being significant enough to move the needle. However, we have many, many clients where if we're able to access $2,700 a month, it's allowing them to remain at a less restrictive setting than a nursing home. When we refer to the personal care residences, you may have a monthly cost that could be $8,000, $8,500 a month if you have someone who might need some additional support for medication management and other things like that. If your recurring income is perhaps $5,000 a month, and then we add for a married vet the $2,771, all of a sudden this check, this tax-free check, is a bridge to making the resources that that person has last longer at this lower level of care. And what we're going to find is that these checks are absolutely critical for people that want to stay home. So again, what appears to be not an enormous benefit actually is a significant benefit because it unlocks the VA healthcare system, plus it actually provides some tax-free cash flow that allows clients to remain lower on the continuum of care. What you'll notice there is there's a reference to a surviving spouse and the opportunity to get $15.15 a month. And again, we use the idea of this being a source of money for somebody who is not a vet, but a surviving spouse of that. Next question, or next slide. So not all vets are going to qualify for aid and attention. And this is just a slide that has a little bit of a checklist that you can use. Discharged under other than dishonorable conditions. And so if somebody has a dishonorable discharge, there is a process to actually request that be modified. Served 90 days or more of active duty with at least 1 day during a period of war. At the end of the slides, which we'll share with you, is a list of the active wartime periods. Now, at one point, I had done a presentation several years ago after I had seen a headline that said all World War I veterans had passed away. And so in order to save space, I made that reference much smaller, only to be reminded that surviving spouses of those wartime vets from World War I are still going to need the information. So when you look at that, those active periods of war, be sure to look at that and understand that surviving spouses may be alive, but the wartime vet does not have to be. This is, again, like a program where we need to see, is the income at a certain amount to trigger eligibility? Are the assets at the right limit to trigger eligibility? Financially qualifying for aid and attendance is important to understand. And then the vet has to be permanently or totally disabled, which in many cases is resolved if they're age 65 or older, because then they're determined to be disabled. What we're going to find, though, is that there's a second analysis that will ask how how many supports does this vet need or surviving spouse need with activities of daily living. So we'll dig into that a little bit. But this checklist gives you a sense that if you have somebody who is not a wartime vet, it's not going to be a pathway for aid and attendance. Next slide. So what is pension poaching? In 2018, the Veterans Administration had called upon Congress to take action to make the VA aid and attendance rules more like the Medicaid rules. If you're familiar at all with Medicaid, if you apply for Medicaid, they have a 5-year look back. If you apply for Medicaid and they find gifts or uncompensated transfers, there is a transfer penalty that will be imposed. And so the VA had hoped to establish a program that would have a review of financial transactions that occurred prior to applying. And when there was an investigation as to how veterans, wartime veterans, were being marketed as to how to access aid and attendance, there were concerns, legitimate concerns about many vets being told to simply just transfer all of your assets, simply purchase an annuity, simply do many things that might have to be undone should they ever need a nursing home level of care or Medicaid, or should they actually not, have any resources left that are directly in their name. So with that, even though Congress did not choose to act, the VA internally, with about 90 days notice, said we're going to revise the rules for when you apply for aid and attendance. And the idea is we want to stop the idea of having wartime vets be victimized by having, annuity sales that were perhaps not as helpful as they should have been, or the ideas of just gifting unlimited gifts without being very, very, very careful. And so pension poaching was a term that was used by the VA and the Office of Inspector General back in 2018 to describe some of the really abusive patterns that they were seeing. What was interesting about the changes in 2018 is that it, I believe, addressed many of the concerns that they had, but it also, in a very helpful way, gave us some really clear answers to questions about eligibility that were just unknown at that point. Next slide. So back in 2018, the things that were changed relating to perceived abuses, the idea of saying that if you have, $1.5 million, that you divest it all into a trust, and that this trust, because it's funded, allows immediate eligibility under the VA. That is no longer the case. If you were to fund and make a large gift into an irrevocable trust, that will cause a floating transfer penalty, and the trust actually will not get the result that you're hoping for. Annuities, what we're going to find is that there's a level of wealth that you're allowed to have and apply for aid and attendance. And again, the idea of just taking all of the resources, putting all of the resources in an annuity is no longer appropriate. The VA also established a look back period. The idea that if we're going to apply for aid and attendance, we need to be able to show what has occurred during the last 3 years. Recall, I just mentioned that the Medicaid look back is 5 years. If we do any VA benefits planning, we have to be careful because 3 years is shorter than 5, and whatever you may consider doing to access aid and attendance will have ripple effects if you need to apply for Medicaid within the 5 years. Penalty calculations. It was confusing when Medicaid changed in 2006 to decide that there was a 5-year look back with a complicated transfer penalty mechanism for when the penalty started. But what the VA did for their 3-year look back is they used a simpler transfer penalty rule that was more similar to what Medicaid was before 2026. If you are somebody that has an interest in applying for aid and attendance and you've made gifts within the past 3 years, you should get advice as to the treatment of those gifts. so that you can understand that the transfer penalty may already have started and may already have been concluded for the VA. Under those tricky cases, that is a floating penalty under Medicaid. So you always need to know the different rules and apply them to the gifts. If someone has made a really significant gift, unlike Medicaid that doesn't have a cap, so if you transfer, $700,000 for Medicaid, you will have a transfer penalty that goes beyond 5 years. But under the VA rules, if you make a large gift, they will cap the transfer penalty at 5 years. And there are possibilities of curing transfers, which are now part of the rule scheme under the aid and attendance. Where did we get help with the changes in 2018? The idea of assets, especially when you think about what an unreimbursed medical expense is and how to actually calculate it. So there's clarity there. How to calculate the income, what are unreimbursed medical expenses, and the treatment of a residence. Before 2018, it was really complicated, and you would have different people with different points of view about whether the house should remain as the residence, with perhaps the vet having a closet full of clothing. Could the vet rent the property and still qualify for aid and attendance? All of those things were resolved with some clear changes in the 2018, so that even if you are not living in your residence, if you still continue to have the residence, it's treated as an exempt asset. So again, some helpful things with the changes from 2018. Next slide. And here is a slide that says, because VA pension is a needs-based program, it is possible to plan, achieve eligibility. Let's unpack this and be very direct. I have not been able to find an accurate statistic, but it's my understanding that there are many, many wartime vets who are already on the continuum of care, who already would be qualified to actually trigger this tax-free income source. This slide talks about the point of view, which is if you understand the VA rules and you're trying to make sure you stay at personal care for as long as possible or stay home as long as possible, if there is a way to adjust how your assets, how your expenses are documented in a way that you would make the aid attendance possible, it's this point right here, which is, do you realize that when you get the information, you may be so close that if you simply understood the rules and took certain steps, you would be able to trigger aid and attendance, which separates the people that are already qualified. So again, as we go through some of these eligibility rules, see if you're somebody who may already be qualified and not have realized it, or see if you may be somebody who could be qualified once you become more familiar with some of these rules. Next slide. The bright line test. Before 2018, when somebody would say, how much money can I have when I apply for Medicaid? That was a clear answer, $2,400, right? Or some people, depending on their income, they may be able to have up to $8,000, not a lot of money. When we applied for VA aid and attendance before 2018, there was absolutely no clear answer. And the best that we could do would be to look at the shortfall every month of where their income was as compared with their unreimbursed medical expenses, measure that gap, look at a life expectancy table, get an actuarial calculation, and use that as their asset limit. We also understood before 2018 that the VA had an internal process that if your assets were below 80,000, they didn't do as deep an audit. So for many times, people that were trying to get information about VA prior to the changes, they were perhaps told it's $80,000 as the number. However, you can have somebody that was much more aged that could have possibly qualified for a much higher asset limit. You might have somebody very young who would be, based on that math, very small amount. So really, it was so personal that it wasn't helpful. Now we have, since 2018, this bright line. And for anyone who's familiar with Medicaid, the VA used as a reference a statistic that's used in Medicaid for married couples. Medicaid says when one spouse goes into a nursing home, there's a snapshot taken of all available assets to give that healthy spouse one half. That's called a community spouse resource allowance. That one half number, which was set in 2018 for that year and year alone, matched what the baseline assets, the cap assets were for VA. Since that time, the numbers for Medicaid and VA have changed a little bit. So if you're somebody who's familiar with Medicaid, you may think, well, I'll just use the Medicaid number for that healthy spouse, only to find that it's very different just by enough to just make it a tricky. But for now, we have this bright line of $159,240, and it will be adjusted for next year. Assets above the net worth limit are considered excess assets and must be reduced to achieve eligibility. The question is, if you wanted to actually look at the opportunity for aid and attendance, what would you want to know so that you could reduce those excess assets? And we will talk about that in a few minutes. Next slide. Unreimbursed medical expenses. The idea is that when you apply for aid and attendance, it's not a question of how much income do you have, it's how much of these unreimbursed medical expenses actually consume your income. So the idea is that there are prescription costs, premiums, long-term care insurance premiums, evaluations, tests, but there is also a concept of something called a personal service contract. So if I have somebody who wants to stay home and I have an adult child who's providing care, there is a fair market value attached to that care. If that child is paid under the personal service contract, that personal service contract has an effect on the income of that wartime vet, because now the contract is saying that this adult child is providing services that consume that unreimbursed medical expense. This is one of the techniques that takes care of that adult child who often has had to stop work, stop funding for their own retirement, allows them to be compensated probably for much less than somebody if they had to pay for a like home healthcare company. But the idea is that we're actually getting real service for somebody and paying that caregiver. And by virtue of that arrangement, we're showing the Veterans Administration that the income is now consumed with the personal service contract, and that's one of the elements to actually triggering the eligibility. So when you think about the question, not for the people that may already be financially qualified because their assets are low and their income is being consumed, but perhaps as a circumstance where you have a family member who's providing on-hands care for their family member who's a wartime vet or a surviving widow, this is an opportunity to make sure they get compensated. And by doing that, we trigger more income for our client. Next slide. Now, what if somebody is not at a nursing home, not at a personal care setting? Because in those cases, it's very clear that the VA would consider those levels of care, those monthly costs, medical expenses. What if you're somebody at an independent level residence? Is that high enough on the continuum of care that the monthly cost would be considered an unreimbursed medical expense? And so, what was interesting about the information in 2018 is they had considered this issue and they did not actually make a change. And so we haven't had that many clients who've been at independent. We did have one and made the point that this is a person who still needs a protected environment. And even though they're not at a facility, in which case, they're not receiving any personal care services, but they are absolutely getting some support, and that it's staffed 24 hours a day with care providers who may or may not be licensed health providers. So independent living arrangements have sort of squeezed in and continue to be recognized as a unreimbursed medical expense. Next slide. The primary residence, I mentioned it before, it was confusing. Really, when was the house going to count as, if the house had a fair market value of 250,000, when would it be counting as $250,000 of assets versus being exempt? It had a very big effect on those applications. And now what the VA has said is that a house is exempt and not countable unless the acreage is more than 2 acres. And so, many people that might have more than 2 acres have to understand that, well, how are we going to actually measure those other acres? There are ways with you get an appraisal and perhaps there's a discount applied to the excess acreage. Some people will say, well, I'm going to just sell my house. If you sell your house, you have to know that the rules from 2018 create a time bunch, which is that if you're going to sell the house, you have to the end of the calendar year, not 12 months, but the end of the calendar year, to reinvest it in another house so that those proceeds remain exempt. The house is still considered exempt. And then if there is a mortgage, of course, that takes the net effect out. Parent lives with a child and the house is empty. There was a lot of concern before 2018. Is that an exempt asset? Now it can be an exempt asset even if the parent's not living on site. And the idea is if the home is rented, again, it can be exempt, but don't forget that the income will actually count towards what income is coming in that has to be consumed by unreimbursed medical expenses. And here's the issue in big letters: can a house be gifted prior to application for aid and attendance? This is, again, one of the things that remains as an opportunity since 2018. And so the idea is that if you have a primary residence, there are specific types of trusts that can and still are used to shelter the property. And the idea is that if the house is going into this special kind of trust, that if the house is sold, it would still count as the vet being the owner for income tax purposes. And there are other things, but the idea is that as long as this transfer of the house into the trust occurs before the application, there is a VA law that says that that is exempt. Transfer doesn't cause a transfer penalty. So for those of you who are looking for these questions about opportunities to accelerate qualifying for aid and attendance, the idea is to understand the personal service contracts and your home and independent living level. Those are treated as opportunities that you might be able to look at to stay, make sure your resources are helpful and available to keep you out of the highest level of care. Next slide. Now, in terms of the look back for the VA, yes, there is a 36-month look back. It's, again, if that number of 150,000 becomes the threshold, it's only assets in excess of that that are going to be the transfer penalties. And if a parent gave away 35,000 for a wedding, is that a problem for aid and attendance? Well, it depends if it came from the assets that were in excess of that threshold or was below. It also, in part, is answered by what was the date the transfer. If there was a transfer and it was 2 years ago, then it may very well be that that transfer penalty began ended and is no longer relevant for the VA application for aid and attendance. Not to be confused that the $35,000 may be a floating penalty for a full 5-year look back under a different set of rules under Medicaid. How does Medicaid consider that gift? It considers a floating gift for the full 5 years. Now, sometimes people say, I know I can give 10,000 per person per year. VA should allow me to give 10,000 away. Well, the number for that annual exclusion gift in 2025 is actually 19,000, and neither the VA nor Medicaid accepts the idea that these annual exclusion gifts are exempt from imposing transfer penalties. So if you're in a pattern of having made lots of these annual exclusion gifts, please know that the pattern is not the rule for VA or Medicaid, and you have to get proper advice to make sure that you understand how to treat those penalties. Next slide. So when we think about this aid and attendance, this pension, there's actually two different labels. There's the one for the wartime vet, and there's the survivor's pension for the surviving widow of the wartime vet. So we would still have the checklist and make sure that the wartime vet met all of the requirements for his or her service. And then the surviving widow or widower can then apply for that pension. If you recall, the maximum pension was $1,515 per month, tax-free. Now, what's interesting, and I think that the year 2025 there's a typo there. The year that common law marriage was abolished in Pennsylvania was 2005. So if you're somebody that considers yourself to have a common law marriage in Pennsylvania, and you can establish it was prior to 2005, then theoretically you may be a spouse, but there is absolutely no spouse that, or common law marriage that's been formed after 2005. The other thing that can sometimes be surprising is that a divorce actually has an effect on the surviving widow's benefit. A divorce before the vet passed away, then there is absolutely no connection to that surviving widow to a benefit. What if a widow remarries? Unless the remarriage ended before 11/1/1990, that is not a spouse that would be eligible. What if you separated without divorce? The idea is that, there may be a longstanding marriage, but actually no formal divorce. And the VA says yes, unless the VA finds marital fault on the spouse's part. I did not find any specific cases on what marital fault could be. I would imagine maybe abandonment or some other type of thing that was beyond the control of the vet. And then deathbed marriages, perhaps this is somebody who has had a long-standing relationship. They know that the wartime vet's going to pass, and they decide to get married. The VA will actually recognize these deathbed marriages as long as they make a determination that it's not in bad faith and not just to obtain any of the benefits. So what is a spouse is not always so easy to discern. Next slide. Now we're going to sort of pivot and think about, let's assume that we want to trigger aid and attendance. How do we take this aid and attendance benefit and reconcile it with the other sources of support that were on that slide that talked about Medicaid and long-term care insurance? How do we make sure that if we're going to get wartime vet, applications in with the income stream, that we anticipate what's going to happen when that income stream shows up? Now, if somebody has long-term care insurance, and the policy usually says when you have a need for at least 2 or more activities of daily living support, or you have cognitive impairment, and just to refresh everybody's memory, what is an ADL, activities of daily living? It's things like bathing, toileting, transferring from bed to chair, walking, feeding yourself. When you have 2 or more of those physical limitations, then you become usually someone that can file a claim and trigger the long-term care insurance benefit. The other pathway is cognitive impairment, And the idea is that you may be cued to do many of those physical things, but that your cognitive impairment means that you really cannot be left alone. So if you have a policy that says, okay, we're going to pay $200 a day, um, $300 a day, whatever your benefit is, if you actually get that and every month you're getting, say, $2,500 of income from, or you're getting a check from an insurance company of $2,500, the question is that treated as income? Remember when I said that we're going to apply for Medicaid for VA aid and attendance, we have to show that the recurring income is consumed by unreimbursed medical expenses. If we have the Social Security and the pension here and we access the long-term care insurance, what does the VA say about the extra check coming in? And what they say generally, which appears to be more favorable than it really is it says, well, we're not going to treat that as income. They don't treat it as income because in many cases, in order to trigger that check, you have to send into the insurance company the example of what the expenses were that are being paid for by this check from the long-term care insurance policy. Another way to look at this is to say, well, if we have income, add the long-term care insurance check, do the unreimbursed medical expenses exceed those combined sources? And the answer is as long as it does, you should be able to still trigger aid and attendance. Now, what's really confusing is not all long-term care insurance is based on the insured submitting invoices proving that they had expenses to get reimbursed. There is a type of long-term care insurance that's called an indemnity policy, where once you meet the medical threshold and you trigger it, you get a certain amount per day. Like example, $400 a day. You may not actually spend $400 a day, but you're being indemnified. And the idea is that if you happen to be one of the few people that has long-term care insurance, and even the fewer people that have an indemnity policy, there is going to have to be a really careful analysis of whether or not you're meeting the idea, the concept that your unreimbursed medical expenses are actually exceeding this income stream. And the final issue is, well, how many of us have long-term care insurance? And what I would say is that I'm still finding many clients coming with the long-term care insurance. They have whittled it down in many cases because of those annual letters. But again, aid and attendance, when you understand how to measure it as income, then part of our planning is to make sure that we document the expenses, the unreimbursed medical expenses beyond whatever that income stream is. And perhaps that's also where the personal service contract will come in. Next slide. Continuing care retirement communities. Some people, instead of aging in their house or waiting to go to personal care or nursing home, may buy into a community, usually at the independent level, with an entrance fee. Those continuing care retirement communities, again, another topic for another day, are considered insurance products. Very rarely is there any interest in real estate. I can think of one CCRC where they actually give you a life estate deed, but that's not typical. And so when you are buying into a CCRC, you may be paying a very large entrance fee. And in many cases, it could be, 100,000, 200, 300, 350. It will be based on the community and then the size of the unit. It used to be when you moved into a CCRC that there were very predictable contract types. And the CCRC as an insurance product had a very straight line to what would have been a very measurable cost, no matter how steep your climb up the continuum of care would be. Said another way, if your entrance fee was non-refundable, then you could expect your monthly fees would be static no matter whether you went up the higher levels of care. But many CCRCs, to sort of compete with the idea that they want to be able to offer a refund to overcome some of the objections of their prospective residents, we've taken a lot of movement away from these traditional contracts to now have many different kinds of contracts. And again, it is a topic for another day, but in many cases, the clients have purchased a contract where it is very much possible that there will be a refund of their entrance fee. So we're not talking about the traditional contracts where it's non-refundable, but we're talking about the idea of this maybe $250,000 refund that could be potentially accessed. Now, many people are thinking, well, I know the contract says that when I die, that my children will get that money back if it hasn't been used. But the concept is that if we're applying for aid and attendance, and we want to make sure our assets that are available are not in excess of $150,000, how does the VA look at these entrance fees? If your contract says, as many of them do, that this is a fee that can be accessed for your care when your other assets are depleted, then clearly it's a resource under the aid and attendance analysis. So when you think about how this refund is going to be looked at as an asset, we really do have the idea that a refundable entrance fee will count as an asset for the VA. It has here, the trend is more for fee for service with the benevolent fund suggestion. Again, that's a lot to unpack in a VA topic, but just know that the contracts for CCRCs are using different language than traditional or modified, and there's more to understand with CCRCs. Next slide. Now, sometimes people will actually apply for Medicaid at a nursing home. They will not only get Medicaid to pay the nursing home bill, they may have come to the nursing home having been a wartime vet who applied for aid and attendance. When that client, patient, resident arrives at the nursing home, that income stream will convert to be $90 a month. But if you have somebody who's at home and there's a category of Medicaid for home and community-based care, that person may actually still get Medicaid and the VA check. And we know if Medicaid is looking at your income as a very specific amount, that if you go above it, you may not qualify for Medicaid in the community. For 2025, that income cap is $2,901. $2,901, and it's the income for just that one applicant. So even if you're married, you're disregarding the spouse's income, $2,901. So is it a good idea to try to qualify for home and community-based Medicaid at the same time you may be already receiving the VA? Pennsylvania Department of Human Services has taken a softening to the position and says that if you are one of those wartime vets, we won't look at the entire check. We will look at only the part of the check that is considered to be the base check. So when you actually get this monthly income stream from the VA, the piece that was awarded to you because of you being a wartime vet who has income that's consumed by unreimbursed medical expenses, that's called your aid and attendance benefit. And that aid and attendance benefit is not counted because by design, they're assuming that it's unreimbursed medical expenses that are triggering that benefit. So again, the note here is if you are a wartime vet and you've triggered aid and attendance and you want to apply for Medicaid, just connect the dots as to when you move into a skilled nursing facility. And if you want to do both at home, you have to run the numbers so you see if you're over the 2,901. I'll drop a footnote here. Again, another topic for another day under Medicaid, but even if your income is over 2,901, there may be things we can do up to $500 to soften that hard number. Next slide. And I think I covered that in the last slide. If you take your VA benefit to a nursing home on Medicaid, it will convert to $90, and that is to be combined with the $60 that you get under the Medicaid. Next slide. So you're probably wondering, how do I reconcile all that I just heard with figuring out whether this is even possible You gather these documents, you get the DD 214 or evidence of wartime service. You look to see the medical evidence. Does my family member need support with at least two or more activities of daily living or have that cognitive impairment? If you're going to be looking into a CCRC, you have to understand the type of contract that you're getting. If you have long-term care insurance, you want to know, do you have an indemnity policy or a reimbursement one? And then you're going to map your Medicaid eligibility. So those are some of the issues that we highlighted. Next slide. We also looked at what is a spouse. Not to forget, you don't have to always be the wartime vet. You can be the surviving spouse, but we do have some real areas where there have been surviving spouses that thought they were eligible only to find that they were not. Next slide. And again, the steps to apply: confirm your service record, document the care needs, submit your medical form, submit the pension. Do you need a lawyer to apply for aid and attendance? Not always. There are many people who will go to a VSO, a veteran service organization, or other nonprofit that is truly in service of vets to access benefits, including aid and attendance. But if you're getting advice as to access aid and attendance and to potentially accelerate the eligibility, it's best to do it with an attorney who's accredited by the VA. Back in 2018, the VA concern was that there were annuity salesmen people and other individuals who were looking at this as a pure VA issue only for pure sales. And the idea is for you to discern that you need to get advice that's not only about VA in attendance, but integrate it with your Medicaid, your long-term care insurance, and your care plan so that all of it makes sense for the long term. So do you need a lawyer? Absolutely not. But if you're going to be making plans to access it where you might need a strategy, that's when you should look for an attorney who's VA accredited. Next slide. So I think we're actually at our time. Before I go into, an example, I think we could, let me see if there's any questions, Allie. Is there anything that I should be wrapping up with based on a question?
No questions at this time.
Okay. So this is, I think, probably too long of an example, but this was a real case where there was an adult child who stopped working and actually moved in with a parent for over 10 years and took responsibility for providing one-on-one care, not having any income, no savings, and no other place to live. And in this case, it was a Medicaid and a VA case where we were able to trigger the aid and attendance check for the father. And that allowed some more cash flow to allow both the father and the son to remain at home. And then also under the Medicaid rules to recognize that this child had been a caregiver child. And under Medicaid, we were allowed to transfer the house from father to adult child without any transfer penalty. The idea is not to look at elder care planning as a way just to protect money, but to protect the idea of being in the least restrictive setting that's safe and accessing all of those resources that were on one of our first slides. So I think with that, I'm going to conclude. If you have any questions and you want to ask them privately afterwards, please feel free to email us. I'll be happy to respond. We'll also make this presentation available on our website.
Great. Thank you, Linda.
You're welcome.
If you do have any questions, you can email info@andersonelderlaw.com and we'll be checking that inbox. And then also, I just want to make sure everybody is aware that to look for our new webinars that are coming in 2026. We're definitely going to have some new and exciting topics. And thanks everybody again for joining today. Have a wonderful rest of your afternoon and a happy Thanksgiving.